Chief Justice of the U.S. Supreme Court, John Roberts, has spent basically his entire career, starting when he was just a little-known Reagan White House staffer, in pursuit of one major goal: eliminating the Voting Rights Act of 1965. And his court has been chipping away at the law bit by bit for years, and today it may have dealt the final blow. Technically, today's ruling was about new congressional maps in Louisiana. Back in 2020, the state tried to draw maps with only one majority black district, even though black residents make up a third of the state's population. A lower court ruled that the VRA required a second majority black district to ensure adequate representation for those voters. Well, today the Supreme Court disagreed. In a 6-3 ruling along ideological lines, the conservatives on the court, including all three Trump-appointed justices, struck down those maps, and in doing so also gutted enforcement of Section 2 of the Voting Rights Act, specifically as it relates to racial gerrymandering. While the conservatives denied what they were doing, they didn't explicitly strike down all of the section. As Justice Elena Kagan pointed out in her dissent, quote, today's decision renders Section 2 all but a dead letter. As it stands, it seems as though states across the country, most notably in the South, are going to be able to rewrite their districts to essentially ensure the mass disenfranchisement of black voters by denying them the opportunity to elect their own representatives. That means they're going to go around and crack apart these majority-minority districts in states like Tennessee and Mississippi and Alabama, Louisiana, and Florida, where just hours after the Supreme Court ruling, the legislature approved new gerrymandered maps in order to dilute the political power of black voters. I mean, the consequences of this ruling today could deal essentially a fatal blow to our current version of multiracial democracy, where we have many black elected politicians up and down the ballot. The struggle to achieve that vision of democracy has always faced fierce political opposition. I mean, after the Civil War, radical Republicans wrote the Reconstruction Amendment, 13, 14, 15 Amendment, and for about 8 years, it inaugurated the first true era of multiracial democracy in the United States. There were black state legislators, state senators, congressmen, senators. Black voting registration and white voting registration levels were equal. And that era was destroyed. It was destroyed by white supremacist violence and terrorism, the Klan. But it was destroyed with the crucial assistance of the Supreme Court in a series of rulings that helped usher in decades of Jim Crow oppression and political terror. And it was about a century later, nearly 200 years after our country's founding, that Congress passed the VRA to once again bring us closer to true multiracial representation. I mean, basically, the Voting Rights Act 1965 was done to revive the portions of our Constitution the Supreme Court had destroyed. Now, more than half a century after that, the Supreme Court has done it again. They've once again intervened to pull us back towards the policies of Jim Crow. Sherrilyn Ifill is a founding director of the 14th Amendment Center for Law and Democracy at Howard University. She was previously president, director of the Council for the NAACP Legal Defense Fund, also the author of Sherrilyn's newsletter on Substack, where she wrote about today's ruling. She's been litigating voting rights for decades, and she joins me now. I first just want to get your takeaway of the decision about how bad it is, a scale of 1 to 10, how catastrophic we should think of it, what if there's anything to salvage out of it.
This is feeling about like a 12, Chris. It's bad. Maybe there are things to salvage out of it. I'm not seeing them at this moment. And frankly, I don't think it does us any good to get to the salvaging stage. I think we have to deal head on with what has happened here and what it means.
Tell me what has happened and what you think it means.
Well, I described in the piece I wrote that, the Supreme Court has, dropped the other shoe on the Voting Rights Act. In 2013, they all but gutted Section 5 of the Voting Rights Act, leaving it standing hollow, removing the preclearance provision from the Voting Rights Act that was supposed to allow us to stop racial discrimination in voting practices before they were enacted. And when they did that, the Supreme Court said, the conservative majority said, you still have Section 2 of the Voting Rights Act, which allows you to sue, to bring cases challenging discriminatory racial practices or districts. Ever since then, we've been kind of waiting for this, but now it has happened. The Supreme Court has essentially done to Section 5 what they did to Section 2. And it's pretty shocking in the context of this case, to be perfectly honest. That makes it even more kind of insulting. But I think what you said at the top, Chris, is that, this is not just about a congressional district in Louisiana. This is about black representation and voice. This is about multiracial democracy. So many of us, didn't live in the period when there was so little black representation. You talked about the Reconstruction period. We had 8 black members of Congress during Reconstruction. We didn't return to that number until 1969. Chris. And the reason we didn't return to that number is all the things that you've described. It was the Supreme Court really gutting the power of the 14th Amendment. It was violence. It was Congress not passing civil rights statutes. All of that was there. But if we think it can't happen, that's what happened. We had representation, and then we had none for decades because of voter suppression, because of gerrymandering, and so forth. And so this step by the Supreme Court is incredibly consequential and important, and we have to look at it with clear eyes.
I want to show this graph or this chart of black elected representatives in the country before and after the Voting Rights Act, which I think we have, which I always think about this chart. I mean, There it is right there, right? Like what you were saying, that little bump in the beginning, which is Reconstruction, and then basically none during the Jim Crow era, and then the Voting Rights Act. And there's another chart that also shows the progression that we're talking about. This is the registration rates between black and white folks over that period of time. And you see that black line is black voter registration, which is on par with white folks during that brief period of Reconstruction. It basically goes to zero, and then it goes back up. So this is what it's meant. What, in a tangible sense, I mean, the first thing you're going to see, I think, is Republican-controlled southern states target the congressional districts that black people represent. I mean, you have Tate Reeves in Mississippi already calling to eliminate the only majority black House district in Mississippi is one of the blackest states in the nation. And we're going to see more of that, I think, as the immediate moves, do you suspect?
Yeah, I certainly do. I think I saw before I came on that Louisiana was thinking about postponing its election for this year. Again, Chris, we should remember that, Louisiana, Georgia, and Mississippi had no black representatives, in 1970, right? And these are places where the black population, in Mississippi was 35%. So if we're thinking that it can't happen, we should know that quite recently, before the Voting Rights Act, that's what we had. And the 1982 amendments, which essentially is what the court really struck down. They will say they didn't strike it down, but they did. They struck down the effects test. This is something that justices on this court have been against for 40 years. John Roberts was a lawyer in the Department of Justice fighting against the 1982 amendments to the Voting Rights Act, calling them a radical experiment. He was the point person in the Department of Justice to try and defeat this amendment to the Voting Rights Act in 1982. It's taken him decades, but now he has defeated it. But the point of the amendment was that they understood that Southern jurisdictions were wising up, and they were not on the record saying explicitly racist things. And so they needed to change the test to allow people to be able to get at discrimination as it presented itself at that time. So what we're seeing now is just the court finally getting what they wanted, at least what some members of them have wanted for some time, which is to create this insurmountable barrier to black voters who are seeking to have their voice and their representation, not just in Congress, but think about your city council districts, your county commission districts, your judicial districts, every place where there is districting that has allowed for black and, of course, Latino also representation is going to have to be on alert and looking for how we manage to keep black voices having power in the political sphere.
One of the things I think it's difficult about covering this court, the court in general, this court, is it can, when we cover Donald Trump or we cover the Republicans in the Senate or the cover, other electeds, right? There's some sense in which there's this kind of democratic agency, right? Like a bunch of Republicans are going to stand for office in the midterms, and if you're really unhappy with the direction of the country, right? Like people can express that. With the court, it always feels like I'm sort of bashing my head against a brick wall a little bit. Today is one of those days where it feels that way, particularly like how do you think about what needs to be done if and when Democrats have power again to change this court that feels incredibly out of control?
Well, I don't want viewers to think even that what the court did today was just terrible from a kind of ideological, democratic standpoint in terms of thinking about minority political representation. I do want them also to know that the Supreme Court ran roughshod over its own precedents, including one from just a couple of years ago, which it tries to explain away so that it can get away with doing what it's doing. I think it's important for them to see that the court itself raised this question below. It wasn't even a question that was being litigated by the parties. I think it's important for people to see that they're essentially rewriting a statute that was written by Congress in 1982 and passed on a bipartisan basis because they didn't like it. I want them to see the excesses of this court so that when and if Democrats do get power, which they say they want after the midterms, they understand that Supreme Court reform has to be at the top of the list. It isn't just that this is a Supreme Court that is controlled ideologically by conservatives. It is that they have abandoned all of the rails and the safeguards that are supposed to give judicial decision-making a measure of integrity. And that means that there has to be serious Supreme Court reform, and soon.
All right, Sherrilyn Ifill, thank you so much for joining us today. I really appreciate it.
Thank you, Chris.